Living trusts are essential tools for estate planning, providing numerous benefits such as avoiding probate, ensuring privacy, and managing assets efficiently. However, the dynamics of a living trust can change significantly when one spouse passes away and the surviving spouse remarries. I'm Daniel Hunt, a certified specialist in estate planning, trust, and probate law. In this video, I'll explain what happens to a living trust after a surviving parent or spouse remarries. A living trust is a legal document created during an individual's lifetime in which they transfer ownership of their assets to a trust. The person who creates the trust, the settlor, appoints a trustee to manage these assets for the benefit of a designated beneficiary or beneficiaries. Typically, a living trust becomes irrevocable upon the settlor's death, meaning the terms cannot be changed. When a surviving parent remarries, several factors can influence the existing living trust, including trust terms and provisions. The original terms of the living trust dictate how assets are managed and distributed. Some trusts may include specific provisions regarding remarriage, while others might be silent on the matter. It's crucial to review the trust document to understand its stipulations. Beneficiaries. The remarriage of a surviving parent does not automatically alter the beneficiaries of the trust. However, the new spouse might become a relevant party, especially if the surviving parent wishes to provide for them. This could potentially lead to amendments or creation of additional estate planning documents. The trustee's role. If the surviving parent is also the trustee, they retain control over the trust assets. Their remarriage does not change their role unless stipulated by the trust. However, they might consider appointing their new spouse as a co-trustee or successor trustee, which could influence the trust's administration. Community property considerations. In community property states, assets acquired during the new marriage may be considered community property, complicating the distinction between trust assets and marital assets. This distinction is vital for ensuring that the original beneficiary's interests are protected. Amendments to the trust. If the living trust is revocable, the surviving parent can amend or revoke the trust, including adding the new spouse as a beneficiary. It's important to consult with an experienced estate planning attorney to ensure these changes align with the overall estate plan and do not unintentionally disinherit the original beneficiaries. Prenuptial and postnuptial agreements. If the couple created a prenup or postnup, these agreements can clarify the ownership and management of assets between the remarried couple, potentially impacting the living trust. A prenuptial or postnuptial agreement can specify that certain assets remain separate property, thereby protecting the interests of the original beneficiaries. To address potential complications and ensure the living trust continues to reflect the settlor's wishes, consider the following steps. Step 1. Review the trust document. Examine the terms of the living trust to understand any provisions related to remarriage and how they might affect the administration of the trust. Step 2. Consult an estate planning attorney. An experienced attorney can provide guidance on updating the trust and other estate planning documents to accommodate the remarriage while protecting the interests of all parties involved. Step 3. Communicate with family members. Open communication with family members, including the new spouse and original beneficiaries, can help prevent misunderstandings and conflicts. Transparency is key to maintaining family harmony and ensuring everyone understands the changes. Step 4. Consider additional estate planning tools. Depending on the complexity of the situation, it might be beneficial to create new estate planning documents, such as a separate trust for the new spouse, to address specific needs and goals. A surviving parent's remarriage can introduce complexities into the administration of a living trust. By reviewing the trust document, consulting with an estate planning attorney, and maintaining open communication with all parties involved, you can navigate these changes effectively. Proper planning ensures that the trust continues to serve its intended purpose, providing for loved ones and protecting assets, according to the settlor's wishes. If you have any questions about what happens to a living trust after a surviving parent remarries, feel free to contact our law firm. Thanks.